So I want us to just start immediately, so that we sleep early. By around 10, there, we should actually be through what you are supposed to cover today. So I remember actually telling you in the topic of formation of companies, then of course you should actually be able to understand what is actually formation of companies. I said sometimes formation of companies is known as actually promotion of a company. And in this regard, I told you you should actually be able to know who is a promoter of a company and what are the duties of a promoter of a company. So of course, we say that promoter of a company is any person who is actually involved in the process of actually having to set up a company as a going concern. When you talk about a going concern, we basically mean that this particular company should actually be able to exist for the foreseeable future. Among the duties, we say that a promoter of a company will actually be able to maybe propose what will be the name of the company. So this company is actually forming. What will be the name of the company? Will it be called Safaricom? Will it be called Equity? Will it be called XYZ company? Then, of course, they'll actually be able to propose what will be the registered office of the company. Where will this particular company's office be located? Will it actually be in Nakuru? Will it actually be in Bungoma? Will it actually be maybe in Kakamega? Will it actually maybe be in Mombasa? And at which building, which floor, which office? So it actually basically also suggests the registered office of the company. Then, of course, we said the promoter will actually also prepare what are known as constitutive documents for the formation of the company. For example, in this case, we said he'll likely be able to prepare what is known as a memorandum of association and an articles of association. So I said a memorandum is basically a document that will actually basically try to talk more about the company to the outside world. For example, if you look at the memorandum, you'll actually be able to see what is the name of the company. So there is what is actually contained in the memorandum will actually basically be the name clause. For example, the name clause will, for example, be what is known as the objective clause, the main reason as to why the company was actually formed, the location clause or the registered office clause of the company, the capital clause, how much capital has the company actually been registered with. Then, of course, it will actually basically also contain what is known as the association clause. The members of the company actually agree to associate as the members of the company. Then, of course, we said in the articles, these are basically the rules that actually manage the internal affairs of the company. So before the company is actually basically formed, the promoter will actually be able to ensure these documents have actually been prepared. Apart from that, we said the promoter will basically appoint the first auditors, basically the first directors. He'll basically also appoint the first company secretary. He'll propose or actually basically select the first bankers of the company, which bank will be basically be the first bank of the company on its formation. Then, of course, if it is actually maybe a public company, he'll basically also maybe prepare what is known as a prospectus. A prospectus is a document inviting the members of the public to be able to subscribe for the shares of a public company, So those ones will basically be among the duties of a promoter in a company, Another key thing we said is that this particular promoter who is actually basically forming a company, he should actually always act in good faith. And basically, if he has made any profits while in the process of actually forming a company, by the virtue of maybe selling some assets to the company, if he makes any profit, he has to reveal to the company after formation. If he fails to do so, then this particular profit will actually be basically categorized as actually being a secret profit. To say that actually that this one is actually against the law, and of course the company has several rights or certain rights against a promoter who has basically gotten what is known as secret profits. For example, if they discover he sold assets to the company at a secret profit, basically a secret profit means this profit was not revealed to the company. So they have a right to basically recover the secret profits from the promoter. Or for example, if this particular asset has actually basically been, is actually maybe, so of course you are saying if the rights have been acquired by a third party, the company can actually, of course, basically recover the secret profits. Or basically they could decide they want to recover the purchase price of the asset from this particular promoter. Then we looked at the ways in which a promoter can be remunerated. We said generally there's no any requirement that the promoter is supposed to be paid a salary or be remunerated for the work done as a promoter of the company. But of course, companies could actually devise ways on how they can remunerate their promoter. For example, they could actually decide to appoint him among the first directors of the company. So that could be a way in which they're remunerating this particular promoter. Or they could actually maybe decide that they are going actually to allow him basically to get free shares in the company, or maybe get shares at a price that is actually basically very lower, or at a discounted price. Or maybe they could actually maybe decide they're going to allow him to sell assets to the company at a profit. But of course, we are saying, of course, he has to reveal the profit. If he fails to do so, it will be taken as actually being a secret profit. Or maybe they could actually maybe decide that, for example, if it is a public company and is actually basically prepared a prospectus on behalf of the company and sold some shares, they could actually give him a commission on shares sold in that particular public company. Or maybe they could decide after formation, they enter into a formal contract that this particular promoter be remunerated. So those are actually some of the ways through which a promoter can actually be remunerated. Then of course, we looked at something known as pre-incorporation contracts. Pre-incorporation contracts. Pre-incorporation contracts. We said basically these are contracts entered into by the promoter before the company is actually incorporated. And I told you basically a company will be seen as actually having been incorporated when it is actually issued with a certificate of incorporation, a certificate of incorporation. So that date indicated on the certificate of incorporation is the one that basically clearly outlines when the company should actually commence business. So anything happening before that particular date on that particular certificate is actually termed as being pre-incorporation. So when you talk about pre-incorporation contracts, are contracts entered into either by the promoter or maybe entered into in the name of the company before the company was actually incorporated. Any contracts entered into before the company is actually formed will actually be termed as being pre-incorporation contracts. Of course, we said there are actually like 4 key rules that govern pre-incorporation contracts. For example, we said number 1, that is actually very key. All pre-incorporation contracts are actually void against the company, and the company cannot actually be liable. So the company won't actually be liable for any pre-incorporation contracts. So the company cannot actually be liable for pre-incorporation contracts. So then we actually also say that if the company renegotiates a pre-incorporation contract, then of course this one would actually be like be validating the contract, or basically forming a new contract that actually now makes the company become liable. So number 1, of course, you are saying pre-incorporation contracts are actually void against the company, and the company cannot be held liable. So you can't actually hold a company liable for any pre-incorporation contracts. Then number 2, if a company renegotiates a pre-incorporation contract, this is basically like forming a new contract. Therefore, in this case, now the contract will now be between the third party and the company itself. So the company will actually be liable for any contracts that are actually renegotiated, or any pre-incorporation contracts that are actually renegotiated. Then number 3, we said any person purporting to enter into a contract on behalf of the company, or maybe in the name of the company, but the company is actually formed, will be personally liable. Will actually be personally liable. And in this case, when you mention that one, of course, you just know this particular blame could actually fall on the promoter of the company. It could actually fall on the promoter of the company, because it's the one who is most likely to enter into contracts before the company is actually formed. Then the last one, of course, you said the company cannot actually enforce a contract entered into before it was actually incorporated. So I think when you talk about that, then maybe I can just share something, because there are case laws. There are case laws here and there. There are case laws I want you to see. I want you to see them. So you can see the usual ways of remunerating or rewarding a promoter include being allowed to sell private property to the company at a profit, by taking commission on shares sold. I've told you how the commission can actually be able to arise. For example, if it is a public company that is basically selling shares, the promoter is the one who will likely prepare a prospectus, a document inviting members of the public to buy the shares of the company. In such a case, he'll likely be given a commission. So being allotted fully paid shares or debentures, being allowed to buy shares at a fair price, being appointed among the first directors of the company. So pre-incorporation contracts, these are contracts purportedly entered into by promoters on behalf of the company before it is actually incorporated. So the following rules relate to pre-incorporation contracts. Number one is what I've just told you. So number one there is that all pre-incorporation contracts are void against the company and they cannot be ratified by the company because it had not come into existence at the time of the purported act. So all pre-incorporation contracts entered into in the name of the company before it is actually incorporated are actually void against the company. The company won't actually be held liable. And there's that particular case law there known as Kellner versus Baxter. You can see what it actually talks about. A company was being formed to buy goods from Mr. Kellner. The contract was made by the promoter on behalf of the company for the purchase of wine from Mr. Kellner. So in this case, the promoter of the company, the person who was actually involved in forming the company, entered into a contract in the name of the company that this particular person known as Kellner was actually supposed to supply wine to the company. So you can see what actually happened. When the company was formed, the wine was delivered to it, but before payment was made, the company went into liquidation. It was held that the promoters were personally liable on the contract as the company could not be bound by the contract. So when this person actually supplied the wine, before just the payment was actually made by the company went into liquidation. So, and of course, I've been telling you on liquidation of the company, or when the life of the company is to come to an end, all creditors of the company are supposed to actually to be paid. Therefore, in this case, this person known as Kellner, the company was owing him some money. But of course, the company could not actually pay or actually rank him as one of the creditors on liquidation because we are saying this contract of supply of wine was entered into before this company was actually formed. It was entered into by the promoter of the company. So it basically means that this company cannot actually be held liable because all pre-incorporation contracts are void against the company. Then number two, if after incorporation, the company renegotiates a pre-incorporation contract on similar or different terms with a third party, this discharges the pre-incorporation contract and the company becomes liable on the newly negotiated contract. You know, this particular act of renegotiating a contract is like forming a new contract. So for example, if you had a pre-incorporation contract, then the company renegotiates the terms, it basically means that the previous contract or the previous pre-incorporation contract has been discarded. And therefore, there's a new contract now between the company and a third party. So therefore, in this case, the company can now be held liable. So you can see what actually happened in that particular case law in Howard versus Patent Ivory Limited. So X agreed with Y, who was acting on behalf of the company, to be formed to sell a certain property to the company for cash. After incorporation, X agreed with the company to take part of the purchase money in debentures and the balance in cash. The contract was held to be valid and the company was bound by it because the variation of the terms as to the mode of payment amounted to a fresh contract after incorporation. So in this case, you can actually see the company actually varied the terms of payment of this particular amount to the third party. So of course, you are saying if the company renegotiates any pre-incorporation contract, this one of course actually validates the contract and actually basically makes the company become liable on that particular pre-incorporation contract. It's like forming a new contract. Then number three, a person who proposed to make a contract on behalf of the company to be formed does so at his own risk, or that even if he was to provide that his liability would cease upon incorporation, he is still liable. So that one is supposed to be, he is actually still liable. This is basically, it means that any person purporting to enter into a contract on behalf of the company, before it is actually incorporated, before it gets the certificate of incorporation, such a person is actually doing it by himself, and he'll actually be held personally liable. Then number 4, a company cannot, after incorporation, enforce a pre-incorporation contract made in its name. So the company cannot enforce a pre-incorporation contract. So there's that particular case law there. So we have Natal Land Company versus Pauline Colliery Syndicate. So N company agreed with a person acting on behalf of a future company F that N company will grant a lease of mine to P. P discovers coal, but N company refused to grant the lease to P. P company sued for specific performance of the contract. It was held that P could not compel N to grant the lease as specific performance could not be granted due to lack of mutuality because the contract would not have been enforced against P, and therefore P could not also enforce it against N. So a company cannot actually be able to enforce a pre-incorporation contract, cannot actually be able to enforce a pre-incorporation contract. And I think we were actually able to look at a question about Mr. Kyoko. Is it Peter Kyoko? So I hope you can actually be able to remember that particular question. So if they bring in any question with regard to maybe pre-incorporation contract, then you need to actually just basically remember the rules governing pre-incorporation contracts, pre-incorporation contracts. So of course, you can actually just see from the rules that we've just talked about, the liability with regard to pre-incorporation contracts is most obviously going to fall on the promoters of the company. So the promoters of the company will likely be held liable for all or any pre-incorporation contracts. So in this case, it basically means that this particular promoter should actually basically be able to devise ways on how he can actually be able to avoid liability, on pre-incorporation contracts, because you are seeing it is just obvious from the rules that any liability on pre-incorporation contracts, the person who will likely be liable is actually the promoter. But of course, he can actually be able to devise ways on how he can actually be able to avoid pre-incorporation liability on pre-incorporation contracts. So some of the ways of how he can actually be able to do so how he can actually be able to avoid liability. Number 1 is, of course, not to enter into any contract, but of course, just to wait until the company is incorporated, such that there won't arise a question of a pre-incorporation contract. So number 1 is to wait until the company is incorporated, then basically use the company to be able to enter into contracts. In such a case, the question of pre-incorporation contracts won't actually arise. Then number 2, he could decide he buys off an off-shelf company, a company that has already been incorporated, then decides to contract with it. Just change the formation of the company, or basically ownership of the company, and basically now decide to basically enter into contracts with that particular company. When you talk about an off-shelf company, is a company that has already been incorporated by someone else, but maybe is not actually basically using the company or maybe trading with the company. So you decide as a promoter, instead of having to undergo all the processes, I just change the ownership of the company and now start contracting with the company. So you can actually decide maybe to buy an off-shelf company, a company that is actually already in existence, then just buy it and now decide to basically just start contracting with the company. Another one is he could agree with a third party if the company fails, or basically if the company fails to affirm or basically ratify the contract, then he won't actually be held personally liable. So he basically just agrees with a third party. This is a pre-incorporation contract. If the company fails to ratify it on formation or after formation, then of course don't blame me as the promoter of the company. So in the agreement or in the contract, he puts a clause that I won't actually be held personally liable in case the company fails to ratify this particular contract. So number 3, we are saying just agree with the third party that he won't actually be personally liable if the company fails to ratify or actually approve the pre-incorporation contract, contract. Another one he could actually be able to devise, or a way he could devise to avoid this particular liability, is to enter into what is known as provisional contracts subject to approval by the company, after formation, A provisional contract is not the real contract. It's just like, for example, maybe you are studying somewhere in a university, they give you what is known as provisional results. So those are not the final results. You'll be given now the final result. So these provisional results normally come with maybe missing marks. So you start now chasing lecturers around looking for your marks. You go where you are told the lecturer went abroad. So that is a provisional result, or maybe in this case is a provisional contract. The real contract will actually basically come from the company after formation. So enter into provisional contract subject to approval by the company after formation. That could actually also be a way on how you can actually be able to avoid a liability on pre-incorporation contracts, because even if this particular third party comes to blame him on this particular provisional contract, it basically clearly states this was a provisional contract which was actually subject to affirmation or basically approval by the company after formation. So those are some of the ways on how you can actually be able to avoid liability on pre-incorporation contracts, because generally we are seeing under the rules that actually govern pre-incorporation contracts that all the blame will actually go on the promoters with regard to liability on pre-incorporation contracts. But of course, you are saying there are ways on how you can actually be able to avoid this particular liability. So of course, you are saying, number one, you can actually be able just to wait until the company is incorporated. That's when you can actually be able to now start contracting with the company. In such a case, the question of pre-incorporation contracts won't actually arise. Another one, you could actually basically maybe agree with third parties that if the company fails to affirm or basically ratify any pre-incorporation contract, then of course it won't actually be held liable. Another one, we are saying he could buy an off-shelf company, a company already in existence, then decide now to contract with the company. So he just changes the ownership, then of course now contracts with the company. Another one, we are saying, of course, you can enter into what is known as provisional contracts which are actually subject to maybe affirmation or actually approval by the company after formation. Maybe the last one, which I could actually add, he could enter into pre-incorporation contracts with an assurance is actually going to be one of the sole directors, or maybe one of the main directors or key shareholders in the company, such that approval of such a contract will actually be very easy for him because he's the majority shareholder. For example, in this case, if you know, of course, I'm going to be the director in this company, I'm going to be the main shareholder or the only shareholder, you won't actually be able to worry, because after formation, you'll eventually just approve any pre-incorporation contract. So you could actually enter into contracts with an assurance is going to be the key director in that particular company. Therefore, approval of any pre-incorporation contract would actually be very easy for this particular promoter, because you are saying promoters are most likely going to become among the first directors of the company, So those are the ways through which this particular promoter can actually be able to avoid liability on pre-incorporation contracts. So I think there's something I want us to look at here. can look at this particular question. You can look at November 2016. I have two questions which I want you to look at. November 2016, question 2A and B. November 2016, question 2A and B. You can see Catherine is saying, kindly clarify, is it buy off-shell company or option company? It's like this: buy an off-shelf company, off the shelf company, a company that's already on the shelf, a company that has already been formed by someone else. So you don't want to undergo that particular tedious process. Someone has already formed a company. You just change the ownership of the company. Then now start contracting with it. Because if you basically look at the procedure of registering a company, it could take maybe over a month or two. But of course, maybe change of ownership could actually maybe take like a few days. So of course, you can get an off-shelf company that has already been registered by someone else. You just buy it. Maybe it's not trading with the company. So it's an off-shelf, like this, off-the-shelf, off-shelf company. Buy an off-shelf company. So I want you to look at these particular two questions, November 2016, question 2A and B. Then look at also May 2016, question 3B. So I hope you've gotten them. I've said November 2016. Have you gotten the questions? November 2016, question 2A and B. Highlight that one. Then also highlight this one. May 2016, question 3B. May 2016, question 3B. So I don't know if you've gotten the question. Collins, have you gotten the question? Collins, Helen, have you gotten the question? November 2016, question 2A and B. Then May 2016, question 3B. So I can see you are saying yes, 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 yes. Even email that says yes. So I want you to just to take like 1 minute and just try to comprehend the question, 1 or 2 minutes. Then we look at them together before we start looking at the procedure of registering a company. And in this case, we shall actually all be interested with Kenya, procedure of registering a company in Kenya. So like 2 minutes, you just try to comprehend those particular two questions. Then we look at them together. Then we start the procedure of registering a company. I think we can look at it together. We can look at it together. You can see that one for November 2016, question 2A and B. So A says, explain the general effect of pre-incorporation contracts. So general effects, basically they're asking you to state the general rules governing pre-incorporation contracts. So if you just summarize them and actually put them there, you'll actually score your marks. So we are saying all pre-incorporation contracts are void against the company. Then the number 2 point, you are saying if the company renegotiates a pre-incorporation contract, this basically validates the contract. Then number 3, of course, you are saying any person who proposed to enter into a contract on behalf of the company will be personally liable. Then number 4, the last one, you're saying the company cannot actually enforce a pre-incorporation contract. So if you just summarize them, you'll actually basically score your marks. Then number B, discuss how a promoter might overcome the liability of pre-incorporation contracts. So that is what we've just looked at. So I've told you, number 1, he can actually basically incorporate the company first before he starts to contract with the company. In such a case, the question of pre-incorporation contracts won't arise. The number 2, he can actually basically enter into provisional contracts subject to affirmation or actually approval by the company after formation. Number 3, he can buy an off-shelf company, then actually contract with that particular off-shelf company, a company already in existence. Then after that, basically contract with the company. Then another one, you are saying he can agree with a third party that he won't actually be personally liable for any liability on pre-incorporation contracts. He basically wants a third party quite early enough. If the company fails to approve this particular contract, then don't basically blame me or basically hold me liable as the promoter of the company. Then another one, you're saying enter into contracts with an assurance he'll actually be one of the key directors or maybe the major shareholder in the company. Therefore, approval of any pre-incorporation contract will actually be very easy for the promoter. Then if you look at this one for May 2016, question 3B, it says, define the promoter. So I've told you a promoter is any person who undertakes the process of actually having to form a company and set it as a going concern. When you say going concern, you basically mean it is actually going to exist for the foreseeable future, with the objective of actually setting it as a going concern. It takes all the necessary steps to ensure that the company is actually formed and actually set up and actually set its operations as a going concern. That person will actually be termed as a promoter of the company. Then in Roman 2, it says, describe 4 legal rights of an incorporated company against promoters who sold their property to the company at a profit while it was in the process of formation. So number 1, the company can rescind or cancel the contract, that particular contract. So number 1 is rescinding or canceling the contract. So they can rescind or cancel the contract. Then number 2, where the rights under the property have been acquired by a third party, they can recover the secret profits. When they talk about the rights have been acquired by a third party, is that the promoter sold the asset to the company, then the company sold it to another person. So it means that the rights have actually already been acquired by another person. So there's nothing they can actually be able to do about that particular property or asset. So the only thing they could actually do is just to recover the secret profit that the promoter actually made. So number 1, you are saying they can rescind or cancel the contract of sale of the assets to the company. Number 2, if this particular assets, the rights have been acquired by another party already, they can just recover the secret profits that were actually made by the promoter. Then number 3, what they can actually be able to do, number 3, if they can actually be able to prove there was actually fraud, damages can be recovered from the promoter. So in case there's actually any fraudulent activity that was actually involved in the sale of the assets to the company, if they can prove there was actually fraud, then they can recover any damages or losses that incurred as a result of the fraud from the promoter. So in case they can prove any fraud, they can basically recover any damages from the promoter. Then the last one, the promoter can be liable for breach of his fiduciary duties. The promoter can be liable for breach of his fiduciary duties. So for breach of his fiduciary duties, for breach of his fiduciary duties. The promoters may be liable for damages for breach of his fiduciary duties, for breach of his fiduciary duties. So that's how basically you could have actually been able to handle those particular questions, So I want us to look at the procedure of registration of a company, And in this case, we are talking about Kenya. How do you register a company in Kenya? Procedure So the first thing that you'll likely be able to do is known as name search. You'll do a name search and reservation online. A name search and reservation online. A name search and reservation online at a fee. So that's the first thing you'll likely be able to do. So basically think of a name that you think will likely be the best for your company. So maybe you want to name it as Helen and Daughters. You want to name it as maybe Collins and Sons. So you think of a name, then you go online on eCitizen. So that is the platform online that you'll likely be able to go there. You look for a place for business registration. You do what is known as name search and reservation online at a fee. You'll be charged a fee. I think it's nowadays it's actually maybe, is it 150 shillings? I don't know. It's 150, I think 150. So you pay a prescribed fee for name search and reservation. So what basically they likely be able to do is basically now to check if that is the appropriate name that you can actually be able to register with your company. Then they, of course, they likely reserve it for a period of 30 days. They likely reserve it for a period of 30 days. So you can just say the proposed name will be reserved for 30 days. The proposed name will be reserved for 30 days. Then number two, what you do, you prepare the constitutive documents, i.e. the memorandum of association and articles of association. The memorandum of association and articles of association. So one thing you basically discover about the memorandum, so what I need to basically elaborate about the memorandum and articles is that these particular documents were actually very important before the Companies Act of 2015. You know, basically the Companies Act of 2015 actually basically came into place to make some of the reasons as to why it was actually approved is to make it easier for companies to be formed in Kenya, such that the intention was companies be formed and maybe they do business with the government. Like the youth can actually be able to form companies. For example, you see that they basically reduced the age for, like, for example, for the directors. Previously, it was that for you to be a director in a company, you must have actually attained the age of 21 years. So they reduced it to 18 years. For example, in this case, previously, these particular documents, they were supposed to be prepared by a lawyer. So you go to a lawyer, he prepares for you a memorandum and articles of association. So because the memorandum, I've told you, it basically has clauses or actually paragraphs that talk more about the company to the outside world. Articles, basically, of course, these are actually rules for internal management of the company. So there are rules for the internal management of the company. Rules for internal management of the company. So in this case, it basically means that previously, before the Companies Act of 2015 came into effect in 2015, of course, these documents you had to go to a lawyer to prepare for you. Your rules of internal management were supposed to be prepared by a lawyer. Then, of course, he actually also prepares for you a memorandum of association. But normally, what normally used to happen, they just used to do what is known as copy pasting and just changing names of the company. Then they just submit to the register of companies. So after the enactment of the Act of 2015, or the Companies Act of 2015, this particular document, memorandum, was basically replaced by certain forms that you'll likely be able to fill online and be able to submit to the register of companies, and it basically actually approve the registration of your company. So you don't have to go to a lawyer to basically prepare for you a memorandum of association. So since the enactment of the Act in 2015, this particular memorandum of association has actually been replaced by forms. So for example, in this case, the memorandum is represented by, so we have form CR1 for seeking registration of a limited company. So if you are registering a limited company, this memorandum will basically be captured by form CR1. So you just fill this particular form and it will basically act as a memorandum of association, Then we have form CR, form CR2 can actually be prepared. So it's actually form CR2. So for registration of a limited company, not form CR1. So form CR1 is for seeking for registration. So form CR2 for seeking for registration of a limited company. So this one basically represents a memorandum of a limited company. So you have form CR3, for example, if it is actually unlimited company. Then you have form CR4, if it is a company that is actually limited by maybe guarantee, a company that is actually maybe limited by guarantee. So form CR2 can actually be filled by a company that has not prepared a memorandum and would like a model memorandum for a company with a share capital, So we can actually have form CR2 representing a memorandum for a limited company. Then we have form CR2. This is for unlimited companies that don't have a limited liability. Then we can have form CR4. If the company is limited by guarantee. So if the company is limited by guarantee, you fill out form CR4. So the memorandum is no longer actually prepared, but it's basically represented by those particular forms, So we have form CR2 for registering a company that has a limited share capital, that is actually limited by share capital, or you can say limited by shares, not by share capital, but just limited by shares. Then you have form CR2, form CR3. It's actually supposed to be form CR. So this is form CR4, this is form CR3. So form CR3 is for companies that's actually limited by guarantee. So companies that are actually limited by guarantee will actually fill out form CR3. Then form CR4 is for a company that has unlimited liability. So this basically represents the memorandum of association. So if you have a company, you want to register a company that is basically limited by, let's say, for example, by shares, then you basically fill form CR2 to represent the memorandum of association. If you basically registering a company that is basically limited by guarantee, then basically you'll fill out form CR3 to represent the memorandum of association. Then if you are registering a company that has unlimited liability, you'll fill out Form CR4. So this particular document, what you are just saying in summary or in simple terms, it's no longer actually needed. It basically has actually been replaced by a form. So just fill out that form and it will represent the memorandum of the company. Of course, all those particular details to do with the memorandum, like they were captured in the previous case, will actually just be captured by these particular forms. So if you look at Form CR2, you'll be able to ascertain what is basically the name of the company and what is its liability. For example, if it is a limited company, then you'll fill out Form CR2. If it is an unlimited company, you'll fill out Form CR4. If it is limited by guarantee, you'll actually fill out for a form known as Form CR3. So of course, you are saying the key thing here is just basically to do the name search first, then prepare the constitutive documents. So the constitutive documents, we're talking about the memorandum and articles of association. So what you need to discover about the articles now, this one, of course, I'm actually also saying is not actually mandatory. This one is actually optional, because you could actually decide to choose basically to prepare your own articles or maybe use the model articles under the Companies Act. So when you're registering the company, they'll ask you, do you want to use the model articles in the Companies Act, or you want to prepare your own articles of association? So of course, if you choose the model articles, then you don't have to prepare your own articles of association. So of course, the key thing, what I'm trying to explain here is that the memorandum is basically represented by these particular forms. The articles is optional. So for the articles of association, it's optional to choose, either the model articles, to choose either the model articles, under the Companies Act, or prepare your own, just say own articles of association. So you have an option. Either you want to use the model articles in the Companies Act. Basically, it means that there's already existence of an articles of association in the Companies Act that you can actually be able to basically apply as the articles of association of your company. So you don't have to prepare it. But of course, you can actually choose the option of preparing your own articles of association. But the key thing here to note that if you prepare your own articles of association, they must actually basically conform with the requirements of the Companies Act. Because I'm saying in the articles, this is basically where you'll find the rules that actually govern the internal affairs of the company. So if you are preparing your own articles, they must conform with the laws that actually regulate operations of companies. For example, if it is things to do with basically rules concerning appointment of directors, those particular rules set out in your own articles should actually basically conform with the requirements of the Companies Act in terms of appointing directors in a company. That's why most people would just prefer to use the model articles. They don't prepare their own articles. For example, you are just registering your own private company. Don't go for the option of basically preparing your own articles. Just choose the model articles. So maybe those companies that have big operations, or maybe several things they have to cover, that's when they can actually be able now to prepare their own articles of association. But most people just prefer to basically choose the model articles already in existence in the Companies Act. Because even if you prepare your own articles, those particular rules that you are setting out in your own articles must conform with the requirements of the Companies Act. And maybe you're a person who doesn't actually maybe understand the law, you can't actually be able to read the Companies Act and prepare your own articles, because this one you'll just be forced to go to a lawyer to prepare for you. So he could actually charge you the preparation of the articles. So you just opt, maybe just use the model articles already in existence under the Companies Act. So you're saying basically the articles, you have an option, either to use the model articles or maybe prepare your own articles of association. So that is actually a very key step that you have to ensure you have actually been able to cover. Preparation of the constitutive documents, that is the memorandum and articles of association. So after you've actually been able to prepare these particular documents, or you basically covered these particular requirements, then the next thing that you'll likely be able to do is to ensure you prepare, so number 3, you prepare a statement of nominal capital. So you prepare a statement of nominal capital. So number 3, prepare a statement of nominal capital, which will be revenue stamped, depending on the share capital, with which the company is being registered, So this one will actually be revenue stamped. Basically, a nominal statement of nominal capital is basically the one that actually outlines how much capital the company is actually going to be registered with at the registrar's office. So basically, of course, it will likely be revenue stamped. What it means, you will pay stamp duty on the share capital that you're actually registering your company with. For example, if you are choosing your company is actually going to be registered with a share capital, for example, of maybe 1 million. So there's a stamp duty you pay. There's a fee you pay known as a stamp duty to the Kenya Revenue Authority. So that stamp duty depends with the share capital with which you are registering your company. So the higher you go, the higher the stamp duty. For example, if you choose 1 million, another one chooses 5 million as the share capital with which the company is registered with, that one of 5 million will likely pay a higher stamp duty. He'll pay a higher fee than the one who is actually registering his company at 1 million. So the higher you go, the higher the stamp duty that you'll likely be able to pay with regards to the share capital with which you are registering your company. So it basically means that you prepare a statement of nominal capital, which will be revenue stamped depending on how much share capital you are registering your company with. So I'm telling you that stamp duty will actually depend on with the share capital. If you go higher, then the stamp duty will likely be a bit higher. Then, of course, after preparing this particular statement of nominal capital, then basically you prepare or basically fill out form. You can say fill out form CR8, fill out form CR8, fill out form CR8, fill out form CR8. So form CR8 is another form that you'll likely be able to fill out, capturing the details of the directors of the company. So fill out form CR8. So fill out number 4, fill out form CR8, fill out form CR8 as notice of residential address of directors, as notice of residential address, as notice of residential address of directors, address of directors, as notice of residential address of directors. So there's another form that you are supposed to fill, known as form CR8. This one will actually basically capture what is the residential address of the directors of the company. For example, if it is us forming the company, it basically capture what is the residential address of Helen, what is the residential address of maybe Alex, what is the residential address of maybe Job. So it likely capture all our residential addresses. So this particular form will basically indicate what are the residential addresses of the directors of the company. So it says basically maybe like a male that stays in a place known as maybe Runda at this particular street. This is his house. So that is what is actually captured under form CR8. So it says maybe someone else stays in maybe Donholm at an apartment known as by this name. So it captures the residential address of the directors, captures the residential address of the directors. Then another one is basically what you likely do is basically to fill out. What you likely do is basically to fill out form seeking for registration of the company registration of the company, fill out form seeking registration of the company, and attach all the above documents, all the above documents that we've actually been able to mention, all those forms we've mentioned above, all the above documents together with, so those particular forms, CR8, statement of nominal capital, the memorandum represented by those particular forms. If you have your own articles, you actually also attach. So this one will actually basically also include together with, so you have the pins of the directors, IDs of the directors, IDs of the directors, IDs of the directors of the company, IDs of the directors of the company, passport size photos of the directors, passport size photos of the directors, passport size photos of the directors, passport size photos of the directors. And the last one, notice of location of the registered office of the company, notice of location of the registered office of the company, registered office of the company, notice of location of the registered office of the company. So basically fill out a form seeking for registration of the company and attach all the above documents that mentioned from CR8, the memorandum, the articles, statement of nominal capital. Then together with that, also attach the pins of the directors, KRA pins of the directors, copies of IDs of the directors, passport size photos of the directors, notice of location of the registered office of the company. So likely also attach that one. Then what you'll likely do after you've basically gotten all these particular documents, what you just do is to, you can say, number 6, submit the application to the registrar, submit the application to the registrar of companies, So you submit all those particular documents to the registrar of companies. So we'll submit them to the registrar of companies, Then the last thing that will likely happen, if the registrar is satisfied that all requirements have been met, if the registrar is satisfied that all requirements have been met, all requirements have been met, he will issue a certificate of incorporation. 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 So that is the process basically that you'll likely be able to undergo when you are setting up your own company. So you basically prepare all those requirements, submit to the registrar. Then if the registrar is actually satisfied that you've met all the requirements, he'll basically give you what is known as a certificate of incorporation. So this particular certificate of incorporation will likely contain the name of the company. So it likely contain certificate of incorporation containing, so you can just say here, contents of certificate of incorporation. So it will have the name of the company, name of the company, name of the company. It will have the date when it was incorporated, date when the company was incorporated. The other thing it will likely have, it will have a unique business number, It will have a unique business number. It will have a unique business number. Then it will have the seal of the registrar. Then another thing, it will be signed by the registrar. If you want to have a look at any company's certificate of incorporation, most companies normally hang them at the reception. So the next time you are actually at any company's reception, look at those particular things they have actually put at the reception. You'll likely be able to see a certificate of incorporation, that this particular company was incorporated on this particular date. The name of the company is this one. That is what you'll basically be able to capture from that particular certificate. You will see the name of the company, when was it incorporated. It will have a unique business number in the corner. This is the one that you basically use to get the KRA pin for the company. It will have a seal for the registrar. Then it will likely be signed. You'll see a signature just down there. So that is the signature of the registrar of companies. So sometimes in the exam, they could ask you, what are the contents or what are the requirements of a certificate of incorporation? If they ask such, then of course, this is what the examiner wants you to basically state there and actually score your marks. So these are the contents of the certificate of incorporation. It will have the name of the company, date when the company was incorporated, a unique business number, the seal of the registrar, and it will likely be signed by the registrar of companies. So another thing you need to actually to be able to notice that after you've actually incorporated your company, then of course you'll be required to meet certain requirements in your company. For example, what will likely happen now, of course, you'll be required to submit annual return to the registrar each and every year. So apart from basically you submitting KRA returns, you'll now actually be required to be making returns to the registrar of companies each and every year. So each and every year, you must actually ensure you are making a return to the registrar of companies. Another thing you likely obviously do, you'll basically look for like a custom for your company, which will likely act as a common sale. So you'll get a common sale for your company. Another thing that you'll likely be able to now start doing, you'll actually now start basically preparing books of accounts for the company. You'll likely basically now start preparing books of accounts for the company. You likely maybe start looking for a bank to open a bank account for your company. You will now basically now open a bank account for your company. If your company basically is one of big operations, you might decide now to include other directors. So you'll appoint directors. You'll now actually now start appointing auditors to audit your books of accounts. Those are some of the part of requirements that will likely be able to be required to meet after you've gotten the certificate of incorporation. So that is what we mean by the procedure of you actually being able to register your company. So a question can actually come in different ways with regard to the procedure of registering a company. For example, they could just ask a question, what are some of the documents that will be attached or likely be needed on registration of a company in Kenya? So there are several documents we've actually been able to look at. For example, pins of directors, copies of IDs of directors. So those are actually documents that will actually be required to be attached. Notice of location of the registered office of the company. So a part of the documents that will likely be required on registration of a company, Or generally, they could just ask you, what is the procedure of registering a company in Kenya? If they ask such, the first thing, the point that you should actually never miss, even if you forget the others, at least you should actually just write the first one, name such and reservation. If you write such as the first point, then if that particular marker, maybe he did not actually sleep properly, maybe he slept for only 2 hours or 1 hour, it just give you marks for the other points, even if you've written, because you'll just see name, search, and reservation. These are very bright students, so it is very sleepy. Maybe you just put a tick on all the others. So don't forget about name, search, and reservation, preparation of constitutive documents, for example, the memorandum and articles. Remember what the teacher said about the memorandum and articles is actually very key. So these particular documents have just been represented by a form. The memorandum is represented by a form, and the articles is optional. You either prepare it or use the model articles in the Companies Act. What did he say about the articles? If you prepare your own articles of association, basically it means that these particular articles must conform with the requirements of the Companies Act. That's why most people just prefer to use the model articles in the Companies Act, because that one is already in conformity with the requirements of the Companies Act. So if your company has any problem, you can actually always go there to refer to the model articles. What are the procedures we are actually supposed to follow, for example, in appointment of directors? You just look at the model articles and you'll actually get your answer from that particular model articles. Then you remember about statement of nominal capital that will be revenue stamped depending on how much share capital you want your company to be registered with. Form CR8, that is actually very important to indicate the residential address. Exactly where does actually Helen stay? What is his residence? It will likely be indicated on Form CR8. Form CR8. Then after you've prepared all those particular documents, then of course you fill out a form, say, for registration of your company, and ensure you've actually attached the details of the directors in terms of documentation. For example, their KRA pins, their copies of IDs, their passport size photos. So they must actually be attached when actually seeking for registration of a company. If the registrar looks at your documents and is actually satisfied that this person is actually very serious and he wants his company to be registered, then of course you would have actually met all the requirements. Therefore, he'll go ahead and actually give you what is known as a certificate of incorporation. So basically, what it means that this particular certificate of incorporation will actually contain the name of your company, the date when your company was actually formed. It will be signed by the registrar just to approve that it's actually a valid certificate of incorporation. It will have a unique business number. It will have a unique business number. It will have a unique business number. So one thing you have to note is that that date that is actually indicated on the certificate of incorporation is actually very key. It's actually very important, and it actually doesn't matter even when the registrar actually signed the certificate. Even if he signed it after maybe 4 days, and you actually commence business on the date indicated on the certificate of incorporation, that business that you're actually doing will actually still be concluded as actually being valid. So maybe registrar alisahau kusign your certificate akachelewa like in 4 days. So unaenda kwa ofisi yao na kuambia that you wait for the registrar to sign, but your company has actually already been given a certificate. So it basically means that the date indicated is more key than even the signature of the registrar of companies, than the signature of the registrar of companies. So that one is actually basically explained by, there's a famous case law known as the Jubilee Cotton Mills, whereby the registrar inadvertently did not actually sign the certificate on the date it was actually incorporated. So this particular company went ahead and actually floated some shares. So the flotation of shares was actually seen as being valid because the date indicated in the certificate of incorporation is actually very key as to when the business should actually commence business. Maybe I should actually show you that one. I can show you that one so that I can show you that one before we see what to do next. So you can see that one there, conclusiveness of a certificate of incorporation. You can see what they are saying there. Once the certificate of incorporation is issued by the registrar, it shall be conclusive evidence that the requirements of the Act in respect of registration and matters precedent have been complied with, and the association is a company authorized to be registered under the Act, and nothing is required to be inquired as to the regularity or otherwise of prior procedures of incorporation. So what we mean is that this particular certificate, it will actually basically be conclusive evidence that your company has actually been properly incorporated. It doesn't matter what actually happened previously, because you've been given a certificate, then of course you have a right to be able to start operations of your company. Even if there was a document missing and inadvertently the registrar did not actually see that the document is missing and he went ahead and actually gave you a certificate, that certificate is actually still valid. It's just like, for example, you've been given a certificate, you've been awarded a degree by a university, they give you a certificate. It doesn't matter what actually happened before you got the degree. So some people say degree it's harambe, degree ni harambe, ni kusaidiana. So it doesn't matter kama ulisaidiwa ndio ukapata degree, because what the employer will actually be looking for, do you have a certificate of this particular course before you actually employ you? So those particular irregularities that are actually involved in basically acquiring the degree doesn't actually matter. What is important is you have a certificate. So that's what you are saying, even if the registrar gives you a certificate and there were some irregularities while the company was actually being formed, or maybe you did not actually conform with the requirements properly, but you went ahead and actually gave you a certificate, it doesn't matter. The procedure does not matter. The certificate is conclusive evidence that you've met all the requirements to be incorporated as a company. So what you can see there, what they are talking about, Jubilee Cotton Mills, you can just read it or you can go through it. Lewis was a promoter of a company for the purchase of cotton mill. The memorandum of association and articles of association of the company were accepted by the registrar on 6th January 1920. Take note of that particular date, 6th of January 1920. And the certificate of incorporation was dated the same date. There was, however, evidence that the registrar signed the certificate on 8th of January 1920. You can see what actually happened. The certificate has actually been issued on 6th of January. But the registrar signed it 2 days later on 8th of January 1920. On 6th January 1920, when the certificate was actually issued, a number of fully paid shares were allotted by the company. The question arose as to whether allotment of shares was valid. This is how it was actually held. It was held that the certificate was conclusive evidence as to the date on which the company was incorporated. The allotment was therefore valid. So you can see this particular company went ahead and actually allotted shares on the date when the certificate of incorporation was actually issued. But there was something, this particular certificate had not actually been signed by the registrar on the date this company was allotting the shares. So it was signed 2 days later. So the question arose as to whether this particular allotment made by the company was actually valid. Was the company actually proper to be able to commence business on the date the certificate was actually issued, or on the date when it was actually signed? It was actually basically concluded that the date indicated on the certificate is the most key one. Therefore, the company was actually proper to be able to commence business and even actually allot shares. So that's what we are saying. The date is actually very key. And basically, when the registrar signed the certificate is not very important. So the date is actually very key as to when the company should actually commence its business, So you can see there what they are talking about, post-incorporation requirements, what I've just been able to explain to you. After you formed your company, if your company doesn't have, for example, directors, you'll be forced to appoint directors of the company, secretaries. You'll be forced to maybe have a common sale or maybe like a stamp for your business. You'll be forced maybe to maintain registers of the company, like register of members, register of directors, register of secretaries, register of debenture holders, register of charges. You'll be forced maybe to keep things like minute books. Those ones will basically contain the minutes of the company meetings. You'll be forced now to start making annual returns to the registrar each and every year. You'll now be forced to keep books of accounts and audit them. Use of name, you'll actually ensure that any document origination from your company has the name of your company. For example, if it is an invoice, you normally see most companies, their invoice, they put their name at the top. So they don't just put it there. It is actually maybe one of the ways of marketing the company, and also it is a requirement that any document origination from the company has the name of the company. You'll maybe open your bank account. You'll actually maybe open your bank account. So I think we can end there today. Then Next time, I'll actually be able to explain to you the memorandum and articles of association. The memorandum and articles of association. I think we'll actually be able to wind up with this particular topic. One thing I can actually be able to tell you is that this particular topic is actually very key. Is very key. So this one, if you go to the exam and you've not read it, it's a big mistake. It's a big mistake. It's one of the topics you should actually be able to have it at your fingertips. If you do an analysis, I've done an analysis of the past papers. This is the most examined area in the exam. It's the most examined area in the exam. And sometimes even certain examiners could actually maybe set up to 30 marks out of 100 from formation of companies. It's actually a very key topic that you should actually have it at your fingertips. Those just small things that you see there, they can test them. So they can test things to do with secret profit. They can test a question just involving formation of a company or registration of a company. So they can test a question about a certificate of incorporation. That thing about Jubilee Cotton Mills, they could just set it in this way. They bring now a scenario. They replace now the names in that particular case law of Jubilee Cotton Mills. Then they ask you, was maybe a particular act that was done by the company with regard to the date of incorporation valid or not? So if they do such, then of course you remember the case law about Jubilee Cotton Mills. So this is actually a very key topic. That's what I normally tell students. If you are very comfortable with formation of companies, then you just add like other few topics here and there. You'll actually be very good to go in an exam. So formation of companies is actually very key. Shares is actually very key. Share capital is very key, and also debt capital. So they are actually very key, a key topic. So formation is the most examined area in the past. It has several questions. If you do an analysis, you'll find that the questions are actually almost like double for each and every topic. If the other topics have like maybe 20 or 25 topics, 25 questions, this one has like 50 questions, like for the past 10 years. So the past 10 years is actually the most examined area. So it's a topic you need to actually to be very keen with. You need to actually be very keen with. So I think we'll be able to look at the memorandum and look at more details about the memorandum and also the articles of association. So I think with that, we can actually be able to end the class there. Then I think we'll be able to meet next time. We'll be able to meet next time and be able to maybe wind up with this particular topic of formation of companies. Formation of companies, but of course I can give you a question just to think about. You can look at November 2016. November 2016. You can look at November 2016, question 6B. 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 I think you can look at that one. So the second one says highlight requirements that a certificate registration must comply with. Just what I've given you here. They're just asking for the contents. Then the first one, describe the requirements that application must meet before the registrar can actually approve it. So they're just asking for the procedure and what are the requirements in terms of maybe documentation. So we just want you to summarize the whole procedure of registering a company. So when they ask for the requirements of the certificate, basically they're asking for the contents of the certificate of incorporation. I think we can end there. So unless you have a burning question, you can actually ask. Then I think we'll meet next time. Otherwise, you guys can have a good night, and we'll meet next time. So unless you have a question, we can have like an allowance of 1 minute. You do so, or maybe we meet next time. I can see Mel asking, now that churches are back, what will happen to the classes on Sundays? We'll see what we'll do. We'll be able to do. We might move them. We might move them. We'll see what to do. We'll see what to do. We might move them, but we'll communicate. We'll communicate. We'll communicate. We might move them because even these exams, we don't know if they'll be there. So we might move them so that people can go to church.